may have been, but also, of course, today it is expected that Dr. Kwesa White, who was in what has largely become known as the strong room of the EC, will testify to some of the issues that he may have witnessed during the election process in 2020. You will recall that the NDC, I beg your pardon, former President John Dramani Mahama, who stood on the ticket of the NDC, is asking the Supreme Court to annul the results as were declared by the Electoral Commission on the 9th of December. Of course, some of the lawyers, that's Nana Boache, who has just made his arrival to the Supreme Court. We'll be talking to him later on. He's one of the communications persons for the legal team of the second respondent, Nana Adodankwa Akufo-Addo. Of course, I was reminding you about the purpose for which we have gathered here in the last 3 or so weeks. It's all because the petitioner wants the Supreme Court to declare the results that were declared on the 9th of December 2020 as null and void, and to ask for a rerun of the election between the petitioner and the second respondent. Largely that's what the court has been hearing, and their case is that neither of the two leading candidates in the 2020 elections gained the constitutionally mandated 50% of the vote cast and more, so 50%, more than 50% of the votes cast. That none of the candidates, especially the two leading candidates in this case, Nana Adodankwa Akufo-Addo and former President John Mahama, attained the constitutionally mandated 50% plus one of the results to have been declared a winner, and they are therefore asking the Supreme Court to declare the results null and void. Of course, Dr. Kwesa White, who was in the strong room of the EC and witnessed it all, will be testifying for the EC. And we're seeing the arrival of many more of the personalities who are directly involved in the election petition. Of course, the first respondent in this election petition is the EC represented by S-chairperson. The chairperson, of course, is Madam Jane Mensah. She has just arrived very soon. We will see her come out of a vehicle. Madam Jane Mensah, the chairperson of the EC, who declared the results. And you will recall that yesterday a major part of the hearing had to do with the viewing of some tapes. One of those tapes had to do with the declaration she made and the subsequent corrections to some of the figures. Yes, and we're seeing her arrival at the moment. And this is the deputy chairperson of the EC, Dr. Bosman Asari. He has also just come, and the lawyers, the judges have also arrived at the courtroom right now, and what it means is that hearing will soon start, and we'll leave it here, and as and when we have more information outside of what happens in the courtroom, and even whatever discussions.
Respectfully, my lords, writ number J1/5/2021, John Dramani Mahama, this is Electoral Commission of Ghana, Nana Adodankwa Akufo-Addo. John Dramani Mahama, who's representing Nana Opoku Ajiman. Representing the petitioner, my lord. Electoral Commission of Ghana. Hello, Sylvia, I know your position, please. Acting Director, Public Affairs, is representing the first respondent. Nana Adodankwa Akufo-Addo. Lord Peter McMahon is representing the second respondent.
If it pleases your lordships, I appear for the petitioner, and with me my learned friend Tony Litha. May it please my lords, Justin Amenuvo appears for the first respondent with A.A. Somoa Samoa.
If it pleases your lordship, Akotuampa for the second respondent. My lords, with me are my colleagues Frank Davis, Kweku Esrefi, and Yao Opon.
My lords, our second witness is here.
I, Dr. Michael Pesa White,
do swear by this cross
do swear by this cross
that the evidence I shall give
that the evidence I shall give
in this case
shall
be the truth,
be the truth,
the whole truth,
and nothing but the truth,
and nothing but the
so
truth.
help me God. So help me God.
SOC, my lords, in English.
Can you get his witness statement, a court copy? Please give your full name.
My name is Michael Pesa White.
And what work do you do?
I teach at the University of Ghana, Legon.
Now, in this matter, in this petition, you have written a witness statement on behalf of the petitioner. Is that correct?
That's correct, my lord.
And your lordships, I believe, will adopt that witness statement. Dr. Pesa White, on the 9th of December 2020, you were at the headquarters of the first respondent. Is that correct?
That's correct, my lord. I was there from the 7th of December to the 9th of December 2020.
You were there with Rojo Metonunu. Is that correct?
That's correct, my lord.
Both of you were there as a representative of the petitioner. Is that correct?
That's correct, my lord.
On the 9th, you granted an interview to Kwesi Parker Wilson of an Accra-based radio station. Is that correct?
That's correct. I granted an interview to TV station.
No. In that interview, you stated that your party had dictated some extra 390,000 ballots in the Ashanti region overnight. Is that correct?
That's correct, my lord.
In that interview, you also stated that the NDC is disappointed and dissatisfied about that and some other processes of the EC. Is that correct?
That's correct, my lord.
In the interview, you also said that some of the pink sheets that were coming in from the regions had tallied. Others had not tallied. Is that correct?
My lord, my recollection is that I indicated that some of the regional summary sheets that were coming in, the tallies were not adding up.
Now, in that interview, you also said that in as much as the EC is trying to improve its processes, it does not need to outsource efficiency and accuracy to the regional directors. Is that correct?
That's correct, my lord.
Now, are you aware that under the rules that governed the 2020 7th December 2020 elections, the regional collation centers were introduced by law?
I am aware, my lord. And what I meant by the statement was and is that under the regulations, CI 127, Regulation 4410, the chairperson of the Electoral Commission, who doubles as the returning officer for the presidential election, was required to be in the collation room with us as the regional summaries were coming in, so that together with her we will go through, and where we have concerns we will together ascertain what the concerns were, arrive at conclusions before we could move on to the possibility of Form 13. That, as at the time I was granted the interview, never occurred, and indeed it never occurred up to now.
Now, Dr. Kwesa White, are you aware that your colleague in the headquarters on the 9th, Mr. Rojo Metonunu, certified some of the regional presidential summary sheets that came from the regions? That's the Form 12. Are you aware?
Yes, my lord, I'm aware.
Can you tell this honorable court those forms that were certified by Mr. Rojo Metonunu?
Yes, my lord. My lord, if you, with the greatest of respect, allow me, I'll refer to my file.
My lords, which document is the witness referring to?
I want to just be sure my lords give the correct regions. It's certified Upper East, Upper West, Volta, Oti, Ahafo, Northeast, Northwestern, Western North, Western region, Bono region, Central region, and Ashanti region.
So, in spite of the concerns expressed in your interview, your colleague certified the forms from Ashanti region. Is that correct?
That's correct. But, my lords, when the Ashanti region summary sheets came into the room, both of us there were representing the candidate, the petitioner in this case, and the political party. We consulted with the party at the regional level to find out what exactly was the situation as far as their computations were concerned. On the basis of what we were told by the party representatives at the region, we certified. Thereafter, we got information from the party at the national level when I spoke to the Deputy General Secretary of the party that the figures the party had collated was far less than what was indicated on the summary sheet that we had certified. And I brought that issue to the attention of the EC officials in the National Coalition Center.
Now, the party representative or the petitioner's representative in the Ashanti region who certified the form before you also certified in Accra is called Broja Dimfi. Is that correct? Ernest Broja Dimfi, is that correct?
That's correct, my lord.
Now, at the time you certified the 12 forms, that's at the time Rojo Metonunu certified the 12 forms, you confirmed from all your regional representatives from the regional coalition centers before you certified. Is that correct?
My lord, I need clarity on the question. Are you asking with respect to Ashanti or with respect to all the other regions?
With respect to all the others that you have just told this court that Rojo Metonunu certified.
Yes, my lord.
Good. Now, let me ask you, was this the first time you were representing the petitioner in the strong room of the EC?
Yes, my lord.
Did you undergo some form of training as part of the learning process?
Yes, my lord.
Did you familiarize yourself with the rules under CI 127?
Yes, my lord.
You are well aware that for the purposes of our elections, declaration of results start from the polling station. Are you aware?
My lord, as far as I know, to the best of my knowledge, the declaration of presidential results only happens at the national level by the returning officer of the presidential election.
Now, at the polling station, when the voting comes to an end, the ballot boxes are opened in the presence of the EC officials and the agents of the presidential candidates. Is that correct?
That's correct, my lord.
And in the presence of the agents and the EC officials, the ballots are counted. Is that correct?
That's correct, my lord.
Now, when the ballots are counted, the entries are made by the EC official on Form 8B. Is that correct?
That's correct, my lord.
And each party's agent is given Form 8B when it is filled out to endorse. Is that correct?
That's correct, my lord.
Now, when the party's agent fails or refuses to endorse, he has to actually state the reason for his refusal on the form. Is that correct?
That's correct, my lord.
And thereafter, each of the representatives of the presidential candidates present are given copies of this Form 8B. Is that correct?
That's correct, my lord.
Good. Now, we then move to the Constituency Collation Center. The representatives of the presidential candidates are also there when all the Form 8Bs are put together and entries are made on Form 9 and 10. Is that correct?
That's correct, my lord.
And again, when your representatives are there, they are given the Form 8Bs to Form 10s and 9s to look at and sign onto it. Is that correct?
That's correct, my lord.
If they are dissatisfied, they are required to indicate their dissatisfaction on the form and state why they are refusing to sign. Is that correct?
That's what's supposed to be, my lord.
Good. Then we now move to the Regional Collation Center. There again, you have representatives there. Is that correct?
That's correct, my lord.
And again, the constituency forms are entered on Form 11 and Form 12. And again, we go through the process of either signing or refusing to sign and stating reasons. Is that correct?
That's correct, my lord.
And copies again are given to the representatives. Is that correct?
That's correct, my lord.
Good. And then where you were sitting at in the National Collation Center, these Form 12s are brought up. That is correct.
That's correct, my lord.
Now, do you know that there's a clause on Form 12 which says that the representatives join the regional coalition officer to declare that the results contained on those forms are a true reflection of the votes tallied from those regions? Are you aware?
My lord, I am aware.
Good. Now, as part of your responsibilities in the strong room, you are the eye and the feet and the ear of the presidential candidate, for that matter, the petitioner. Is that correct?
That's correct, my lord.
So therefore, it is part of your duties to be there at all times. At least you are two. So if one is out, the other is there. Is that correct?
That's supposed to be the case, my lord.
Now, it is therefore, in my view, wrongful on your part to be suggesting that both of you left the strong room on the 9th. I'm putting that to you.
My lord, could you please go over that again?
Pardon me?
Can you please go over
I'm
that?
saying that it is therefore wrong for you to be indicating in your witness statement that both you and Rojo Metununu left the strong room on the 9th.
My lord, we only left on the instruction of the chairperson of the Electoral Commission, who happens to be the returning officer. And we did so because in the performance of our duties as representatives of the petitioner, we observed a number of issues that were of concern to us, which had the potential of undermining or creating problems for the ultimate outcome of the election. And in fact, it's not particularly surprising that presently both the first and the second respondents have also indicated in their witness statements that there were errors. It is in the spirit of that we tried to have a conversation with the returning officer, who, although was expected to be in the collation room with us, was never present, visited the room only twice, lasted for more than 2 minutes and went back. But we made efforts to bring this to her attention. And in the spirit of making sure that we work towards producing the most credible election results, we took her words of going to see our flag bearer to discuss the issues with her in good faith, and went accordingly.
You had your phones with you, is that correct?
We had
your phones, your telephones with you?
Yes, I had my phones with me. By the 8th, it was dead because I didn't carry my charger with me.
You had your computers with you, is that correct?
We had our computers.
There were journalists moving through and fro in that room, is that correct?
That's not correct.
I am putting it to you that there were people, there were journalists and key stakeholders moving through and fro in the room, and therefore you leaving was wrongful.
My Lord, there were no journalists in the room. I recall that there is a gentleman in the room who was doing videoing of what was happening, virtually there for the entire period we were there. And at some point, this gentleman was calling agents of the candidates, asking them to express their views on the process as it was happening. Of course, we declined that particular invitation. Journalists were not allowed inside that room.
Now,
I granted 2 interviews, but in granting those interviews, I had to make sure that I asked somebody to call those journalists for me so that I could express to them what exactly it is that we were experiencing.
Yes. Now, it is not true that you were instructed by the chairperson, who was not your principal, to leave the room. It is not true.
My Lord, it is true. I have no reason for lying. The reason is simply this. When we were leaving the room, we informed in the open room, to the hearing of everybody, I believe, that we were instructed by the chairperson of the Electoral Commission to go and consult with our flag bearer, who is the petitioner, on the basis of our observations. And thereafter, she was going to make sure that she sends a rider to bring us back to the strong room because of the potential of traffic. Then, therefore, when we finish the process, then the results could be announced. Now, on the basis of this, when we were leaving the place, we left our laptops. We left in only one vehicle. I left my vehicle in the presence of the Electoral Commission. Why would we leave our laptops and our working tools in the place when, if we were not actually instructed to go? Besides, there were representatives of the Peace Council and there were observers in the room. And I personally approached one of the representatives of the Peace Council and informed him that this is the situation now and that we were going to be back. Indeed, we returned to the place in about 45 to 1 hour, only to have the strong room completely deserted, everything packed out. And yeah, that's what it was.
Do you know that even as we speak, there is not a single complaint of refusal to sign from 12 from your candidates, that's from the representatives of the petitioner? Do you know, even as we speak in this court?
My lords, with the greatest of respect, the representatives of the candidates at the regional level, I believe, is what you are referring to.
Yes.
But in the strong room, we were also there to carry out due process. And that is to say that it does not necessarily mean that once forms come from the regional level, signed or unsigned by our representatives there, we must or should automatically also endorse it. We were equally required to do due diligence, because between what they have signed and what had arrived in the room, we needed to be sure And so, with the greatest of respect, my lords, even though they signed, I don't think that that necessarily mandates us to sign every form that arrived.
I am repeating this question for you, that as we speak, all the 12 or 13 Form 12s that were endorsed by your original representatives did not have a single complaint beside it. I'm putting that to you.
My lord, that's not correct, because there is, with the greatest of respect, if I could refer,
my lord, if the witness can indicate what he's referring to so that we can follow him.
There is the form for Western North, where our representative did not sign and had written that the results from Seviwosu were massaged. Now,
but is it not the same Western North form that was certified in the strong by Rojo Metonunu?
That form was certified.
By who?
Of course, by Rojo Metonunu.
Thank you.
But, my lords, after certifying that form, he then drew the attention of Mr. Sribo, who was working with us in the coalition room, that we have complained from our representative in that region, and therefore he signed in error.
Fantastic. Now, you are well aware that by all these forms that we have gone through for the court, you either sign or you indicate refuse to sign on the forms. You are well aware.
Yes, my lord.
You are well aware that failure or refusal to sign or just leaving the form blank was not an option. You are well aware.
My lord, in the strong room, our understanding was that we were there to make sure that ultimately whatever is declared as the outcome of the election reflects the will of the people. Therefore, we
are well aware.
Therefore,
Mr. White, please,
my lord,
answer the question. If you go about it, who doesn't know that the strong room is for you to go through whatever has been submitted and certify it? Oh. Be allowed to give a lecture before he answers the question.
Right, you answer, and then if you have an explanation.
Yes, you respect. Be allowed.
Thank you, my lord.
You are well aware that simply refusing to sign or indicate reasons or leaving the form blank was not an option for the purposes of the regulations that govern this election. That's what I'm asking you.
My lord, we are well aware.
Thank you.
But this is why the reasons were not stated. We had been asked by the Electoral Commissioner, when we brought our concerns to her attention, to go and have a deliberation with the petitioner. If she had allowed us to come back and she was still not convinced, we would have duly indicated those reasons there and allowed the process to continue. As it were, the process was truncated.
I have put it to you that you were not instructed by the chairperson of the first respondent to leave the room.
My lords, we were instructed by the first respondent. I had no reason whatsoever to just lie or deceive this honorable court if that was not the case. And as I had indicated, our living there was not in secret. We openly told almost everybody who was there that based on our discussions with the first respondents, this is what the outcome is, and that we were going to be back. The reason for which we left everything we had at the place.
I am putting it to you that what you have just stated is false. And I'm further putting it to you that if it were true, well, my Lord, I'm grateful.
The question. Yeah. So allow the witness to answer the question.
Now, I am putting it to you that the EC chair did not instruct you to leave the strong room.
My lords, I maintain that we had no reason for leaving the place. Indeed,
I am.
Yes, she did instructed us to leave. And my lords, on the Saturday after the declaration, I believe an official of the EC had said in public that he had seen Mr. Rojo Metonunu gone to the Electoral Commission chairperson whilst we were there. Of course, this official may not be privy to what they discussed, but I can say and maintain that it is on the basis of her instruction that we exited the place.
I am further putting it to you that if what you were saying had any iota of truth, you would have provided at least one wee bit of corroborative evidence. I'm putting it to you.
My lords, the evidence is the fact that in leaving the place, we left everything we were working with. In leaving the place, we informed everybody else in the room, in the open conversation, that we were leaving the place and we will be back. Indeed, in leaving the place, we had no reason to believe that the chairperson of the EC was deceiving us and that was going to announce the results before we returned. But beyond that, my lords, at the time we were leaving, we had not come anywhere close to even knowing who had won and who had lost. The reason being that we were in the process of looking at region by region by region before we could move on to Form 13. As it were, and as it is now, we have never been presented with Form 13. We have never seen Form 13. We have never had the opportunity to actually have all the candidates and their results listed on Form 13 for us to vet again. The entire process was truncated. We were there to make sure that we had this thing done to the end. The only reason we left was because the first respondent had asked us to do so, and we did so in good faith. We did so in good faith in the interest of our democracy.
You see, on that day, you never spoke with the chair of the EC, did you? Yourself, you personally, never spoke with her.
My lords, we were there working as a team.
Please answer the question. I'm saying you.
I, as an individual.
Yes. You didn't speak with her.
I did not speak to the EC chairperson personally.
Thank you. Thank you. Now, do you know why the forms had signed, or if you refuse to sign, indicate a reason? Do you know why? Do you know?
I don't know.
You don't know? Well, let me tell you what it is. The reason is that if there are irregularities, signing or indicating the reasons on the form, it will go to the next upper level and it will come to the notice of the EC officials there for resolution. I'm putting it to you.
My lords, as far as we were concerned, we were not given the opportunity to exhaust the processes that we were undertaking in order for us to come to a conclusion that our issues were not resolved, and therefore we were going to list them on the form.
Now, I am also putting it to you that the forms as endorsed is countersigned by the officials, and this becomes a certified complaint if indeed there are complaints on it. I'm putting it to you.
My lords, could you please take the question again?
I am saying that once you had earlier on agreed that if you indicate a refusal or you sign, it goes to the EC official who countersigns it. And I'm saying that if the EC official countersigns it, it becomes a formal complaint in the system. I'm putting that to you.
My lords, that is why I'm saying we never got to the point where we could have indicated the reasons on the form. That opportunity was denied us.
That, you see, you didn't get the opportunity because your very agents and representatives in the regions whom you are trying to discredit in this court endorse the forms without complaint. I am putting that to you.
My lords, I am not trying to discredit our agents in the regions. I am saying that what happens at the regional level, which is the third level as narrated in the first respondent statement,
now
happens at that level. What happens at the national level, there is a reason why we were to be there. It doesn't mean that what comes from the regional level could be devoid of errors or mistakes. And it is in the process of going through that we identify material irregularities that we were bringing to the attention of the chairperson of the Electoral Commission.
Now, simply walking away or melting away, as you did, was not an option for the purposes of the forms.
My lords, if walking away was an option for us at any given point in time, we probably would have done that long ago. We had never at any point in time imagined walking away, and we never walked away. We only exercised the option of going to see the petitioner because the first respondent had asked us to do so, and we had no reason not to believe that she was acting in good faith, only for us to realize we were deceived into getting out of the place. Besides, the reason why we believe strongly that we were deceived was originally the announcement of the election results was scheduled to take place at the International Conference Center. We were all told, everybody was aware. We were all prepared for it. Less than 10 minutes after we left the place, as I was told later by others who were in the room, the chairperson, together with the officials of the EC, came to call them upstairs and hurriedly announced the results. This, for me, indicates that there was a deliberate decision to deceive us.
Melting away or walking away by you two, you and Rojo Metonunu, was in the relation of your duties to the petitioner.
My lords, we never walked away.
As a result of you being in the relation of your duty, you then concocted this story and fed it to the petitioner, leading to the filing of this ill-fated action.
My lords, if this was ever a concocted story, we would not have left our laptops and our working tools in the EC's premises in the strong room. If this was a concocted story, we would have left in our individual cars. If this was a concocted story, we had no basis telling everybody else in the strong room what the deliberations between us and the returning officer was and why we decided to do what we were doing. Besides, some of the agents, after telling them that the chairperson of the EC had asked us to go consult with the petitioner and come back, had told us that we hope you come back in time so that we can complete the process. So there was no reason why we would at any point in time on our own walk out of the place, my lords.
So, yes, my lord.
Because the word keeps changing. What exactly is your evidence? Are you saying that the chairperson of the first respondent instructed you, asked you, advised you to leave the room? What exactly are you saying?
My lord, I take it as...
Because in some instances you say instructed, in others you say asked. What exactly?
My lord, she instructed us to go and consult with the petitioner.
The chairperson of the first respondent instructed you?
The chairperson, yes, my lord.
Secondly, Mr. White, May I ask you to, may I ask you to be a bit slow in your answering because the recorders, yes, have to work.
My Lord, unfortunately, I can't tell who is talking. May I know who is talking? I can't see or whoever was talking right now. I don't have to see. Oh, okay, I see. All right, that's fine. I could only hear voices, so that's why I'm asking. I wanted to be sure it's an accepted comment.
I think it's because the camera is locked.
Your time, because
okay,
it's been recorded.
Okay, I'm grateful, my Lord.
Now, you see, you never left any property of yours in the strong room. I am putting that to you.
My Lord, we left our laptops, calculators, and bags in the strong room. I personally left my vehicle within the premises of the EC. And by the time we had returned to the place, in fact, if we did not leave any properties of ours at the place, why would we have returned to the place in the first place? Then there would have been no basis to return to the place. We went back there to get our things.
You see, you didn't leave anything in that place because that was the place that Form 13 was posted at. I am putting that to you.
My lords, Form 13 was posted at where?
The very strong room that you left. That was where Form 13 was posted at.
My lords, I need clarity. This is unclear. We left the place and came back. When we came back, the place was deserted. There was nobody else there except the gentleman who I believe takes care of the facility, who was there. No. So I'm not too sure how Form 13 comes in, because as I had indicated earlier, neither myself nor my colleague was ever shown, given, or asked to look at Form 13 and certify or sign. It never ever happened.
You see, Dr. White, you didn't see Form 13 because at the time it was being filled, you had melted away. I am putting that to you. You didn't see Form 13 because at the time it was being filled, you and your other representatives, who were the eyes of the petitioner, decided to just vamoose.
My lords, we were asked, or if you like, instructed, and I should say that I use these terms, these words interchangeably, but it's also intended to mean instructed, to go and consult with our flag bearer by the chairperson of the Electoral Commission. Now, this question about we left because Form 13, that's the reason why we did not see Form 13. At the time we were leaving the place, my lords, we hadn't gotten to where we should even be having conversation about Form 13. We were looking at results through their summary sheets coming in region by region. We needed to complete that process, and then Form 13 would have been processed based on my understanding and projected on the screen so that we can compare the values on the regional summary sheets with the values indicated on the Form 13. This process never occurred, never happened, and I don't want to believe that between when we left and came back, which was not more than 45 minutes, the entire process that involves Form 13 had taken place, everybody agreed, signed, and results were declared. I'm putting pressure on the recorders. I'm sorry, my lords. I'm sorry. I'm sorry.
But you agree with me. You agree with me that at the material time that you left, you had seen and certified 13 of the 16 Form 12s. Is that not so?
My lords, as far as I know, we did not certify 4 regions. So that brings those we certified to 12, because we have 16 regions. Now, I should indicate that even if it was just a single region that we did not certify, my lord, that for us was very important. The reason being that behind the numbers are the wishes of people expressed in votes. And we wanted to make sure that in the end, irrespective of who was winning, the declaration reflects the exact will of the people of Ghana.
The four Form 12s that your original agents did not sign, they also did not indicate the reasons for their refusal to sign on those forms. Is that not so?
My Lord, may I refer? My Lord, the 4 regions that we did not sign, the reason was not because our regional reps did not sign.
Oh, please answer my question. When you make life difficult for me, answer the question. I'm saying that the 4 regions that your regional representatives did not sign, they also did not indicate the reason for their refusal to sign on the forms as required by the CEI 127. Answer the question.
Yes, my Lord.
Good. Are you aware that out of those 4 regions that your representatives in the regions did not sign or indicate their refusal, the petitioner won 3 of those regions?
My Lord, that is precisely the point. If our interest was just in winning.
Mister, you see, we've advised you, when you answer the question, you can add whatever you want to add.
Yes, my Lord.
Explanation.
Yes, my Lord. Could you please take the question again, my Lord?
I am saying that the 4 remaining regional Form 12s that your regional representatives did not sign, out of those 4, 3 of those regional forms had the petitioner as the winner.
Yes, my Lord. And that is precisely why our issue should be seen as very genuine. Yes, the petitioner had won, but we were not just interested in the winning, but also the votes and whether they truly represent and reflect the wishes and desires of the people. And we have noticed irregularities that we thought needs to be rectified. If we were there only to see forms that the petitioner was winning, I believe that we would have signed. But to the extent that, yes, the petitioner won those regions, but we did not sign and had raised issues, it's a clear indication that we actually were making sure that the writing is done according to law.
According to the law, raising issues must be on the Form 12s. Did you indicate any reason on any of the Form 12s?
My Lord, we did not, because we never got to the point where an opportunity to indicate reasons on the form was provided. Besides, the particular form that we are talking about, which I believe is Form 12 from the regions, had no space on the form for representatives in the strong room to put their signature and comments if they have any issues. The forms that came in as summaries did not have that particular column or space provided for us. So assuming we were even stating reasons why we were not signing, my lords, there was no place available for that.
You see, if you had any reason to refuse to certify Form 12, you would have indicated on it the same way that your representatives signed, that your colleague Rojo signed and certified on all the others. I am putting that to you.
My lords, with the greatest of respect, I don't know whether it is possible to show how Form 12 looks like in this court so that my case will be made clear. I am saying that on that form, there is no space whatsoever for writing of comments if you have any concerns. I have a sample of that form here, my lords. This is the Bono East form. The columns here have no space whatsoever.
Are you referring to a sheet from your
My lords, I'm referring to just one of the regional summary sheets.
It's coming from, it's just in your possession at the moment.
My lord, I believe so, my lord.
You must refer to what.
My lord, if we go to my exhibits, the one on Eastern region, it is actually the same form.
Go. Now, can you read the right part? There's a heading. In fact, start from the top.
Okay.
Where they sign, right? Start from the left column. Read all the headings for the hearing of the court on the Eastern regional sheet that you have.
Okay. Thank you, my lords. I'm reading it, but against the background that this. Okay. Name of agent at the regional level. Party. Name of party or candidate, signature of the agent at the regional level, reason if refused to sign at the regional level.
Thank you, my lord. Now, you indicated that you have not seen Form 13. I want you to look at the petition, the first respondent's Exhibit 4.
Could you please, my lords, can I please have a copy? Okay.
My lords, whatever is being shown to him, we need to know what is being shown to him. Because
my lord.
Yeah, counsel for the petitioner is saying that whatever you want to show to the witness in the box, by the would I say the practice, settled practice, the counsel must have a look at it.
My lord, I wanted to show to the witness Exhibit 4.
Oh no, it passes through counsel. It doesn't take anything away. Yes.
You don't? No, Exhibit 4 attached to the first respondent's witness statement. You are looking at the Form 13 regarding the 7 December 2020 elections, Exhibit 4. Is that correct?
My lords, that is not correct.
Now, the Form 13 was signed by 8 of the agents present at the time, the form that you are looking at.
my lords, that form is not in evidence at this stage. I thought that he was showing it to him
in order to raise some issues about credibility, maybe if he had signed it or something like that. But that form is not in evidence, and he cannot be asked questions about the contents of that form. It's not in evidence, my lord. And the witness has stated quite clearly that no such form was presented at the time that they left. So that form cannot be the basis on which he can be asked to make references as to the... With respect, I wish to withdraw the document
it's
from
not
him.
yet in evidence.
That's what he has seen.
Thank you.
Now, you see, at the time on the 9th that Form 13 was filled out and signed, you and your colleague, Rojo Metununu, had left the commission.
My lord, at the time this form was prepared, which by the way, we don't know what time it was prepared, we have been instructed by the first respondents to go and have deliberations with the petitioner on the basis of the irregularities that we have identified and had asked and had brought to her notice.
I am putting it to you that the first respondent's chairperson never instructed you to leave the commission.
My lord, the first respondent did instructed us to leave the place.
I am further putting it to you that you indeed did not even personally speak to her. She cannot instruct somebody whom she hasn't seen. Yes, my lord. Yes, my lord. Yes, my lord. Now,
yes, my lord.
But in your witness statement, you stated that she asked you to go. Why do you insist on using instruct now? In your witness statement, you said she asked you.
My lord, I believe I had said earlier that I'm using instruct and ask interchangeably.
But the two words don't mean the same thing. The two words don't mean the same thing. We all know that.
Now, I am putting it to you that all the figures on Form 13 is a summary of all. Can't I put it back to the figures on Form 13, which is not in evidence? That's impermissible.
But Mr. Chikata, he has recognized that he received training for his role. So I don't think that the question refers to a specific Form 13. Form 13 is a generic form, isn't it?
I was listening to the question that he asked.
So was I.
And I did not hear him say a generic Form 13.
Neither did he say the specific one. So let's see what the witness
in the
says.
context, the only Form 13 we've been talking about in the last 5 minutes is what he sought to tender. So in the context, I think in order not to mislead the witness, if he's talking about a generic clear, so that the witness...
That's appreciated.
My Lord, I will address the court on it. Now, you were not present at the commission because you left when you realized that the petitioner had lost the election.
My lords, that cannot be true because as at the time we were instructed to go and have deliberations with the petitioner in that room, we had come nowhere close to knowing who had won and who had lost because the totals as they were coming from the regions had not been put together, and of course there were issues with some of them, so we couldn't have even put the totals together and decided that candidate A or B had won the election. So there is no reason why anybody should believe that we had left because we noticed that A or B was losing the election. Besides, we did not go into that room with a fixated mindset that by all means our candidate must win. We went to the room to make sure that whatever the summary sheets that were coming from the regions were reflects the true will of the people who went out to cast their votes on the 12th of December 2020.
You see, the fixation that you have is what you have just displayed in this court. Now, let us go to your exhibit that you have attached to your witness statement. Mr. Esiedun Ketia asked me to ask you about how that letter came about.
My lords, as we began noticing challenges with the summary sheets that were coming in, we considered it proper to relay the information to one, the petitioner, and two, the political party on which he stood as the presidential candidate. And as we relay it to them, we also told them that we had sought audience with the first respondent. I should say that we sought audience twice with the first respondent. In the first instance, when my colleague went, she told him that I have heard you seem to have some genuine concerns, give me a few more minutes and I will get back to you. The second instance was when she instructed that we should go and have deliberations with the petitioner and return.
But up to that point, you didn't deem it fit to register your complaint in the mode set out under CI 127.
My lords, as I had indicated earlier,
answer the question, please.
Because there was no space on the form for us to indicate the reasons.
Oh, okay. Now, did you mean this letter to be an official letter?
My lords, the question again.
Did you mean this letter to be an official letter? The exhibit attached to your witness statement, did you mean it to be an official process?
To the best of my knowledge, yes.
Now, as a lecturer, I believe that when you deliver an official process, it ought to be receipted for. Is that correct?
That is correct, my lord.
Now, look at your document and tell us where it is indicated that it was received at the headquarters or any other branch of the first respondent. Indicate for me.
My lords, there is no indication of it on the letter, but it is important to be cognizant of the circumstances of the time between the 7th and the 9th, if not earlier. The entire Electoral Commission's building was cordoned off with heavy military and police presence. That made it almost impossible for anybody to ply even the public roads that were just beside the Electoral Commission. Now, when the letter was written, at the time the letter was being brought, we were on our way to hold consultations with the petitioner. The letter was brought in by the Deputy General Secretary of the party in...
You are saying in one breath that you were not there.
Yes, my lord.
How can you give this evidence of who brought it there and all of this?
My lord, I am speaking in respect of what I know happened.
Yes. You were not there.
My lord, I believe that not being there does not necessarily mean that I will not have knowledge of things that may have occurred.
No, you can't. Unless you tell us how this knowledge was acquired.
The knowledge was acquired through interactions with those who were directly involved. And therefore, the letter was brought in by the Deputy General Secretary in the company of lawyer Thonilita and lawyer Marietta Opomburu and other officials of the party. When they arrived, they had to stay behind the police military cordon off.
Dr. White,
This evidence is not admissible.
Thank you, my lord.
If any of the persons that you have mentioned,
we are alive.
Yeah. Thank you, my lord. They are alive. In fact, they are present.
Yeah.
So let's come back to the letter. There is no indication on it that it was received. Is that right? Yes. Okay. You also did not send the letter by email.
To the best of my knowledge, no.
You see, I am putting it to you that this letter was put out by you, your party, in the public domain to create a certain scenario in the country. It was never received by the first respondent.
That is not correct, my lords.
I am further putting it to you that this letter was generated by you in order that you hide your failings as an agent of the petitioner in the strong room.
That's not correct, my lord.
And I further put it to you that this action it came about as a result of your failings and the falsehoods that you have peddled.
That's not correct, my lord.
And I'm further putting it to you that you are not a truthful witness.
My lord, I am a very, very truthful and credible witness.
And finally, that the petitioner is not entitled to any of the reliefs.
My lord, to the best of my knowledge, the petitioner is entitled to all of it.
My lords, that will be all for the witness.
Sorry. Yes, my lord.
Second respondent, counsel.
Now, Dr. Professor White, I'm putting it to you that you know that the chair of the EC has no power to instruct either you or Metro Nunu.
My lords, I know that.
So, I'm furthermore putting it to you that if you left the strong room, you did so on your own volition and based on your own judgment.
My lord, that's not correct.
Now, you see, part of the burden of your witness statement has been to demonstrate, as you put it in this letter, MKW1, that Ashanti region provides fundamental problems that require investigation. We have found out that almost across board, the aggregates on the summary sheets do not reflect the individual results on the pink sheets. Is that not so?
Yes, my lord.
Now, I'm putting it to you that that was the basis of your allegation in the press that over 390,000 votes had been, there are problems with them.
Yes, my lord.
Yeah. Now, you admit that in the petition of the petitioner, he makes no such averment?
My lords, I believe...
No, please. No.
My lords...
I'm saying that you know that in the petitioner's petition, he makes no such averment about 390,000 votes.
My lord, he did.
Well, the court will determine that. Now, I'm also putting it to you that when, according to your tale, you were leaving, the two of you, one of you could have remained and the other have gone. Is that not an option?
My lords, the weight of the issues we were going to discuss with the petitioner requires both of us to be present.
So are you suggesting that if one of you went and said that, Mr. Petitioner, this is what the two of us have agreed upon, so what I'm relating to you is based on our common position, the petitioner would not have heard you?
My lord, I don't know.
That is a good question. Answer. Now, I'm therefore putting it to you that your witness statement adds absolutely nothing to the case of the petitioner.
My lord.
Mr. Kutamba, this is a matter for addresses.
My lords, my witness statement.
My lords,
okay,
so that will be all for the witness.
Oh, thank you.
Please, there will be questions from the bench.
Dr. White.
Yes, my lord.
Kindly look at an exhibit, the presidential election regional results summary sheet.
My lords, please, I couldn't hear you.
Presidential election regional results summary sheet is attached to your witness statement.
Attached to my witness statement?
Yes, your witness statement.
Okay.
Eastern region.
Eastern region, yes, my lord.
The one with the... Mr. White, Dr. White, look at the one...
Yes, my lord.
Now look at the far right column.
The far...
right column, the bottom part.
Okay.
Reasons if refused to sign. Do you see it?
Yes, my lord.
So are you seriously saying that if you had any reason to refuse to sign, you couldn't have registered it there, that column? I want you to be very... Are you seriously saying that this column could not take any reason for a refusal to sign?
My lord, with the greatest of respect, this form is designed purposely for regional representatives at the coalition center at the regional level. They are the ones who are required to sign and a space made available for them and state reasons. At the National Coalition Center, my lords, no space whatsoever is provided on any form whatsoever to indicate why we have a concern and we needed it registered. And in fact, it is in consideration of that we decided that let's have a conversation with the returning officer and raise our concerns.
Agree. So you agree with me that at the regional level, there's a space for parties representative to assign reasons for not signing?
Yes, my lord, but not at the national level where I was a representative.
All right. One minute.
Professor White.
Yes, my lord.
You said you received training or before assuming your duties.
Yes, my lord.
So you've seen the Form 13 before?
Form 13?
Yes.
I have seen the Form 13 during the training process, yes.
All right. I'm going to show you a copy of the Form 13 that has been brought to this court.
Okay.
It's not in evidence yet, but I'm going to show it to you. Please show it to his lawyer and then show it to you. Do you see a column that is headed reason for refusal to sign?
Yes, my lord.
Thank you.
And my lord, if I may, this is not Form 13.
What is it?
Only the first respondent can answer. Because if you look into the CI 127, a sample of the Form 13 is there. It requires you to list the regions and list the candidates and their individual votes as obtained from the regions. This form only listed the candidates, the votes they obtained, and then subsequently had agents and the candidates and signature. So this is not Form 13.
So when you say that the Form 13, as you know it, does not have a place for indicating your refusal to sign, you are thinking about what is in the law?
My lord, I have not said, my lord, I have not said the Form 13 as I know it. I only said we were not given any form in the National Coalition Center that requires or has a space for us to sign.
Thank you.
Thank you, my lord.
CJ. Look, Doc, I have a very simple question. Is there a reason why there should be the two of you in the strong room at the same time?
Yes, my lord. I believe it is for us to be able to confer. For instance, the process involves a lot of calculations. And if I may, at some point, my colleague has to be mentioning the figures for me one by one, whilst I calculate them, both on the calculator and then in the Excel file. So there obviously was a reason why we have to be two. And I noticed that the CI actually says that agents must not be more than two.
All right. So if there was consent for you to leave, and in a heightened, circumstance like that, do the two of you go?
Madam, sorry.
No, please, because you see, you were there for a purpose.
Yes,
for
my
the
lord.
petitioner, his eyes, body, everything was you.
Yes, my
lord. You were
lord.
going to confer with the petitioner.
Yes.
What were you expecting him to say? Because you were the ones receiving the regional results. So if you have to go and confer with the petitioner, wasn't it enough for one of you to go so that one stay around and see exactly what is happening?
My lord, with the
Looking
greatest
at the atmosphere.
My lord, with the greatest of respect, the question itself suggests that the first respondent cannot be trusted.
No.
And therefore, we should have left one person there. I indicated to this honorable court, my lords, that we acted in good faith and realized later that we were deceived. And so, yes, there was that option, but we exercised the option that will allow us to give the petitioner the best of information that was available to us. For instance, my lord, whilst he was there meeting with the returning officer, I was in the strong room. He needed to inform the petitioner what exactly he was discussing at that time, and I needed to tell the petitioner what I was observing whilst I remained in the strong room. So it was important that both of us left.
Doctor, I want to be very clear on some of these issues. Now, you've already told this court that you were not sent to the strong room to take instructions from the chairperson of the first respondent. Is that correct? Your presence in the strong room was to see to the cause of the petitioner, but not to take instructions from the first respondent. You were asked this question and you admitted, you say yes.
And I indicated that.
Please, you said yes, you are not to take instructions from the first responder.
My Lord, yes.
So, when the first responder said, go and consult the petitioner, what were you going to discuss with the petitioner? You were in the strong room for a purpose. He told you to go and consult the petitioner. On what? I want to know.
My Lord, on the specific irregularities that we have brought to her attention, and she did indicate also that the reason she was asking us to do so that all the stakeholders, including the NPP, Peace Council and others, could be invited to ensure that we have a credible results before the announcement is made.
But you know that part of your duties in the strong room, at the end of the day, if you have refused to sign, was to indicate the reasons why you had refused to sign.
My Lord, it appears to me that there is a particular side of this narrative that has not been very clear. I am saying with the greatest of respect that the forms that arrived in the room and within that room itself, there has been no space whatsoever for us.
No, I don't mean that. I am saying that at a point in time in the strong room, there will be a time for you to indicate your displeasures on what has happened.
My Lord,
to the EC.
We know that, and we had hoped to get that opportunity, but that opportunity was denied us.
Please. Then, you see, would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you are saying is true, you did not help the cause of the petitioner who sent you there?
My Lord, I don't believe that is true. We were working in furtherance of making sure that the results that ultimately gets announced by the first respondent reflect and represents the will of the people. And if she asking us to consult with the petitioner is part of how we could get there, we were happy to do it.
But then, seriously speaking, you did not take your training seriously. You know, no, please.
It's not an appropriate question.
I want to be clear. You've gone to do a particular job. Then, instead of doing a particular job that sent you there, you take instructions from somebody else. Then you leave your job. You see, that's what I want to find out. Then you did not help the petitioner.
My Lord, with respect, his Lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he has answered. He has, in terms of, his Lordship can have his opinion. That's his opinion to have, and he can have it as well. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take deference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, oh, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. But how am I harassing him?
Well, you're harassing him respectfully because the petitioner has indicated that it wasn't just somebody told them that go and talk to the petitioner. The petitioner has indicated that the returning officer...
The witness or the petitioner?
The witness. Thank you for the correction. The witness has indicated that the chairperson, not just anybody, the chairperson, who is the returning officer, was the person with whom his colleague had the conversation, and on the basis of that, they were sent to talk with the petitioner. And he has given every account of why they thought it fit that both of them should go. Now, so if repeatedly an opinion is being put to him, that is harassment of the witness, and that's not allowed.
My last question.
Thank you.
My last question, Doc. Just by the way, what do you lecture at the University of Ghana? The subject, please.
My Lord, I teach public policy.
Okay, thank you.
Right. I have one more question for you. I want to be clear in my mind. You've said in evidence that you never spoke to the chairperson or the first respondent. You said it.
My lord, I did say I never spoke to her in person.
Yes.
But I do know that my colleague had spoken to her on our behalf.
No. So how did she instruct you? The person never spoke to you. You have admitted on oath.
My lord, I am surprised at this question. What? The reason being that...
Why are you surprised?
I'm surprised because...
the question I'm asking emanates from your evidence.
Yes, my lord.
So wait. Dr. White, wait.
Thank you, my lord. Sorry about that, my lord.
I'm saying that you have admitted on oath that you never spoke to the chairperson.
Yes, my lord.
So I'm asking, how was the instruction issued? Is it not a fair question? Why are you?
It is a fair question, my lord.
So why
the instruction was issued through my colleague, Rojo Betelnunu.
Yeah. So
and on the basis of that, we had to comply. Thank you, my lord.
No re-examination.
Order in court, please.
Counsel, may we know whether this is the last witness for the petitioner?
My lord, we have an application in respect of our request for inspection of certain documents. And the outcome of that application will determine whether we ask leave for a further witness, because we've only filed two witness statements, and we would need to ask leave. But the outcome of the application that we have pending will affect the decision that we make.
Thank you. Yes, Mr. Amenuvo. Have you been served?
Yes, my lord, we have been served.
Okay. Yes, Mr. Kotampa.
My lord,
have you been served?
We've been served.
Then, do you have any objection to the application?
My lord, with respect, can the witness be...
Oh, let me discharge him. Yes.
Can he be discharged?
Yeah, oh, certainly.
Thank you, my lord. I'm in a hurry to go. Thank you, my lord. Order in court, please.
My lords, with the greatest respect, I mean, I appreciate, yes, but my lords, is it that the Supreme Court requires people to be in a suit?
Yeah, but well, we insist, it is just an advice to him. It's nothing. I'm not taking anything away from him, sir.
My lords, the only reason I rise in connection with this is that if the word goes out that whenever lecturers are coming to the Supreme Court, they have to be in suit, Because I mean, that. Well, order in court, please.
No, we are raising the status of lectures.
Sorry, Mr. Menuvo, are you opposing the application?
Yes, my lord. So
Mr.
My lords,
Akotampa,
we are opposed to.
Okay, then we will adjourn it to tomorrow. Yeah. If you have any process to file, Mr. Chika.
No, my lords.
You have processes to file.
Yeah. Please, we want to. Sorry, excuse me. Please, do you want to have it argued today or you?
Yes, my lord, it was filed today and served today. My lord, if you, with the kind permission of the court, get an hour and a half, we can come and file our opposition if my lords want to take us later in the day.
My lord, then we might as well be given the opportunity to file it by the end of the day and we'll argue tomorrow. Yeah.
Order in court, please.
By court, the petition is adjourned to Wednesday, the 3rd of February 2021 at 9:30 a.m. for motion for an order for production for inspection of documents. If after the motion there is the opportunity for us to continue, we may do so. Thank you.
All rise.
Bodo Tamalenku Koriansu Abewae Misenya yanka edube sapakemu Misenya yanka edube sapakemu Rabeji enu Rabeso yemu Rabeji enu Rabeso yemu Na yebreo 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 Na yebreo 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 Na yebreo 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 Na yebreo yebreo yebrepa Rabeji enu, Rabeso yemu, Rabeji enu, Rabeso yemu. Ejo, bodo. Anana nyumre, inamkonko baby. Ibeja mitina mi huse kroma efeba, kroma ye nice, sekra ye fine. Bibi sayana yesi mahamane yeye wayadi Koshe rijisu Koshe kotoka Sisi sku wadai Muma yempinine wayadi Yebezu Mahama yebeza Yebezu Zu yebeza Mahama yenkasa Risa fedie yehu Hey Yasiya feda nehu yamuodu Yebreo Na yebreo Na yebreo Na yebreo yebrepa Echo Kodo Agbewae Factories no ahe, empty promises, and one a yati, hey, Mahama bro, JM bro, wana bombo, Mahama bro, JM bro, Ona, Mahama bro, JM bro, wana bombo, Mahama bro, JM bro, wana po, ehecho, wana po, kodo, wana po, yebreo, na yebreo, Na yebreo Na yebreo yebrepa Rabeji yenu Rabeso yemu Rabeji yenu Rabeso yemu
Mahama, Sankofa, Sankofa Inchi, John Mahama Nepe, Yanu Yamu, Sankofa, Sankofa Inchi, John Mahama Nepe, Yafi Mahamo, John Mahama Nepe, Yafi Mahamo, John Mahama Nepe, Yanu Yamu, John Mahama Nepe, Yanu Yamu, John Mahama Nepe, Nayepe, Sankofa. Sankofa Inchi, John Mahama Nepe, Sankofa Inchi, Sankofa Inchi, John Mahama Nepe, Yanu Yamu, Sankofa, Sankofa Inchi, John Mahama Nepe, Sankofa Inchi, Sankofa Inchi, John Mahama Nepe, Sankofa, Sankofa Inchi. John Mahama Nepe. Omanuma Yadio, Omanuma Mahama, Asisa Wajinu, Emma Odinada, John Mahama Nepe. Yanu Yamu, John Mahama Nepe. Ghana Florida, John Mahama Nepe. Sanko, Sanko, Sankofa Inchi. Ghana for John Mahama Nepe. Sanko, Sankofa. Ghana for Mahama Nepe.
The observations that they had made of irregularities that were significant in terms of the credibility and integrity of the results. They left in good faith in the expectation that after consultation they were going to come back and then continue with the process as stipulated by law. However, as you all witnessed, that was not to be. Immediately they left. A few minutes after they left the strong room, the chairperson of the Electoral Commission surreptitiously and hurriedly went ahead to declare the results in their absence. Now, she basically ran all the time-honored practices and conventions that were established by her predecessors. There is a precedent that was established in 2012, where the New Patriotic Party agents raised a number of issues relating to the results that were coming in. The former chairperson of the commission, in the person of Dr. Afarijan, called a meeting of all the parties and their agents and the key stakeholders. And they sat around the table, addressed those concerns that were put before him, and then ultimately declared the results. And we were all witnesses to what happened thereafter. The current president brought a petition together with his vice president and the late Jake Obiche-Bilamte to the Supreme Court, and it played out for 8 months before the Ghanaian public. So what happened on that day when she decided that she was not going to wait for them, out of respect and courtesy and in accordance with due process of law, to consult with His Excellency John Dramani Mahama before coming back for them to redress the issues, the concerns that had been raised, shows the utmost bad faith that she exhibited. It also shows that she was determined, and this bears repeating, she was determined that by hook or by crook, His Excellency Nana Addo Dankwa Akufo-Addo would be declared the president-elect of the Republic of Ghana. Now, I am sure as you watched, there was a lot of, how would I say, questions relating to the so-called Form 13. Now, that is the presidential elections, declaration of presidential results form. You notice, for instance, that counsel for the first respondent, on his feet, tried to smuggle in the Form 13, the so-called Form 13, through the back door, because that wasn't an exhibit attached to the witness statement of Dr. Kwesa White. When lead counsel for the petitioner, Mr. Tachu Chikata, objected, and his objection was upheld. One of the justices of the Supreme Court, to our utter surprise, decided that that must be made an issue with respect to the evidence of Mr. Kwesa White, Dr. Kwesa White, sorry. And through her, the form was shown to Dr. Kwesa White. Now, ladies and gentlemen of the media, Form 13 is not a figment of anybody's imagination. It is a creature of statute. It is in CI 127. Now, Dr. Kwesa White made it abundantly clear, and I am sure this will come out during cross-examination, that what was shown to him was not Form 13. And counsel for the first respondent was in court. He did not object to the fact that Dr. Kwesa White described it vividly as a form other than Form 13. Now, what does that tell you about the credibility and integrity of the elections results that were declared by the chairperson of the Electoral Commission? If you can declare elections on a fictitious form, and I say fictitious advisedly because that form does not conform to CI 127. So where did she get that form from? We will leave that for you in your questioning of the EC, in your questioning of the second respondent, to elicit the information with respect to where that form was gotten from. Then also the venue of the declaration. It came out very clearly that the venue of the declaration was changed without consultation. They sent invitation letters earlier to all the parties. Conference center. And we were all aware that the declaration of the presidential results for December 2020 was going to take place at the International Conference Center. But because of the lack of good faith and the fact that she was operating from a predetermined position of declaring the results in favor of Nana Addo Dankwa Akufo-Addo, immediately our agents, the agents of the petitioner, left. She hurriedly went upstairs and declared the results in their absence. And now they are in court blaming our agents for leaving, even though it was at her instance that they left. And by the way, you don't need to communicate to two people before your message will sink. She communicated with Honorable Rojo Metil-Nunu regarding the consultation with the former president, now the petitioner. And so it was not absolutely necessary for Dr. Kwesa White to have had a conversation with her before proceeding to go with Rojo Metil-Nunu to see the former president. So if you saw the line of cross-examination by lawyer for the first respondent, and then subsequently and unfortunately by some of the justices of the Supreme Court, indicating that Dr. Kwesa White ought to have been present when the conversation took place. That was rather unfortunate. And you saw some of the scenes that played out in court today, where the witness was being harassed left, right, center, because his evidence clearly was against the grain of the narrative that the EC and Nana Addo Dankwa Akufo-Addo's lawyers have been trying to put out.
Why both of them left?
That both of them left because they did not want to, they noticed that their candidate was losing. So we are here today in very high spirits. I can see from the, the faces and the body language of Professor Nana Jane Opoka-Jiman and my chairman that we had a wonderful day in court. And I am sure that, in fairness, if this evidence is anything to go by, on Judgment Day, we will be smiling. Any questions?
Doc, from the very beginning, when the EC chair was appointed, your party had raised concerns about her being fair during the elections. And you had a time where you had Dr. Kwesa White and the other representative being in the strong room, going to the EC chair to go and have conversation with her. You've always had doubts about her fairness. When she told you that you could go and meet your petitioner, with this precedence of you doubting her fairness, why didn't you allow one of your representatives to remain at the strong room whilst the other goes? Because you always doubted her fairness anyway.
Right. Now, we did that. The witness himself explained why that is the case, and that was because the two of them played different roles as agents of the petitioner. And it was important that they both, would go and explain the concerns that had been, observed. So, for instance, if Rojo Metil-Nunu forgot something in explaining to the petitioner, then Dr. Kwesa White could fill in the gaps. And then also, we gave her the benefit of the doubt. We left in good faith because she was performing a constitutional duty. And we thought that she would go by the letter and spirit of the Constitution, and that she would also go by the letter and spirit of CI 127, which requires that you don't finalize, okay, and sign off the results of a presidential election without the agents of the political party. These are time-honored principles and conventions that have been established within the EC and within IPAC for purposes of the declaration of results and for the sustenance of the credibility of results. That didn't happen. Yes, sir.
Yes, sir. Thank you very much, counsel. Having listened to the testimony of Dr. Kwesa White, most of his testimony bothered on information given to him by Mr. Rojo Metil-Nunu. Would you have rather presented Rojo Metil-Nunu as a witness?
No, I don't think that matters. The fact is that there were two agents of the petitioner working in concert to advance the interests of the petitioner. And so relying on one agent's information or advice with respect to what to do, for me, that doesn't matter. It doesn't take away from the fact that the chairperson of the Electoral Commission acted in bad faith. Any more questions?
Yes, Doc. A number of very short questions. Number one, listening to you, I get the impression that some of the judges misunderstood the case that was being presented by your witness. Indeed, the witness himself had to, on several occasions, try to address and readdress some of the concerns. Now, these are the people going to pass judgment on the case that you have brought before them. If they have misunderstood you, and on the other hand, you are saying on Judgment Day you will be smiling, will you indeed be smiling? Number two, indulge me, please. Number two, there's a question of harassment of the witness. Indeed, a lot of us watching who are not lawyers and who have always held the court in high esteem, and the judges for that matter, were scared at a point when we saw the witness in a kind of a direct confrontation with some members of the bench. And indeed, the lead counsel did same on the question of harassment, which matter you have repeated here. Is it safe for you and your case with that kind of a direct confrontation with the bench? And finally, the former president had attended to
I think you are going too far. Can we take your questions one at a time? I'm even beginning to forget your first question. Right? So let's take your one at a time. Can you summarize, crisply the first question, and I'll take that, and we proceed to the second one.
Okay. So the first question has to do with some members of the bench misunderstanding your case.
Okay.
Are you worried about that?
I don't think so. As an experienced practitioner, I am quite sure that they understood what Dr. Kwesa White was saying. I am pretty sure there was nothing unclear about the evidence that he gave. All right. Judges are allowed to ask questions for clarification. What they are not allowed to do in terms of the law and ethics of judging is to descend into the arena of conflict. Now, as to whether they descended into the arena of conflict, I will leave that to you to judge.
Number two, on the question of conflict and harassment, what we saw in court, for a lot of us who don't understand the court processes, is it healthy for you and your case? That direct confrontation with the bench.
I don't think that detracts from the probative value of the evidence that has been given. Okay, he did a good job of standing up. Okay, as far as the issues that he was called upon to address are concerned, he was very credible. He was eloquent, and you heard the judges saying that he should stop lecturing.
Number three, finally, the former president, whose case it is, had attended to the court diligently up to the end of last week. The whole of this week, I haven't seen him. Just asking, where is he? And how is he?
The former president is well, and carrying on, the business of being the leader of the NDC. Of course, the party chairman ably represents him on a daily basis. In fact, chairman has never been absent, and I am sure, and of course, the running mate is here as the person who was on the ticket with him, and she has not also absented herself even once from court. So there's no issue about representation. The former president is not required to be in court on a daily basis in order for his case to be heard. Otherwise, if that were the case, I'm sure the judges would have been asking where he is. Since they haven't asked, it's in order.
Doc, you've put in a request to inspect some documents. Earlier, I had seen a process that was directed at the Electoral Commission. Right. If you could explain how this is different from that one. And secondly, looking through the list of the documents, are those not documents that are supposed to be in the custody of the petitioner through his agents? And I also recall that this issue came up in the 2012-2013 petition as well.
Yeah, that is so. You will recall that we filed a notice to inspect the documents. The notice was duly served on the respondents, and the first respondent in particular has custody of all those documents. And by the way, this is to inspect the originals. It's not about us not having the documents. We want to authenticate what was provided to us and what has been put on the website of the Electoral Commission, and that motion will be heard tomorrow. So I wouldn't want to take up some time on that one.
All right, Doc, thank you. I'd like to help to break down one of the issues to the understanding of our viewers. It's got to do with the witness using the words asked and instructed. To ask is not the same as to instruct somebody. He used the words interchangeably. He doesn't work for the EC and therefore should not have been seen to be taking instructions from the EC. And if the EC actually asked him to do something, he wasn't compelled to do that. You've spoken about acting in good faith. Yet, as my brother asked earlier, you had expressed some unfaithfulness in the EC itself. And so where did the good faith all of a sudden spring up from?
Okay, thank you very much. On the question of the difference between asking and instructing, I think Dr. Kwesa White used instruct in order to emphasize on the fact that they accorded some level of respect because she is the authority, the ultimate authority. She is the returning officer under the Constitution. And all the political party agents in that strong room worked, if you like, on her instructions, on whatever directive she gave, to the agents. And so the fact that he used the word instruct does not in any way suggest, okay, that they were taking instructions from her instead of taking instructions from His Excellency John Dramani Mahama. Remember that the petitioner was their principal, and as agent they worked, directly to the principal and for the benefit of the interest of the principal. And so I don't think that it makes any difference whether they took instructions from her or they were asked to go and consult with the former president, and they duly complied. As I said earlier, they were acting in good faith. Little did they know that the person they were dealing with was acting in bad faith or intended to act in bad faith. They came back after yes, and they came back after 45 minutes. Okay, and the question is, why could she not wait? Okay, we waited. This was on the 9th, right? Yes. We waited 2 days for the results. We could have waited another hour for the results to be credibly, compiled and released to the people of this country. Yes, that, yes, but the thing is this, my brother, okay? She is the only constitutional officer that you have to work with. She is the sole constitutional officer that you have to work with. So the fact that we express, some reservations about her even-handedness and so on prior to the elections doesn't mean that we could have stayed away from working with her. And we decided that we're going to work with her in good faith. She decided otherwise.
All right. So
thank you very much.
Let me do that count quickly. Wait. Sorry. I'm saying, it's your court and then a Samoa. And Debia Samoa can say electoral commission. As our bonny team posse. Kwambias no Obama Nana Kufuado I president no enne Uche Obimfo Pesa White Nen Samo de Beto a year court enimno a day di pefe se a do baby crano or dada ye nipe name Sifu anom what them ho se omunko no omune a year John Dramani Mahama candidate no unko dinkita ho a sign in Sembia no ma pega enko ye what them ho. Ewie chire no omusi abonten omukoye no enusima mienu anamiensa kra no okoye and oko declare elections no ne dika o se hunu se na wanye dika ka kire Ghana for na se election ye be declare no awo conference center ensu ka kire wom se wom nkoni ne nkodi nkita no mfa mu ayemra no omusi abonten enu 45 minutes and omukoye na electoral commission dem ho Omoko declare adiano. And then so I say form be a or use declare results no form no ha. And then yenya judges no back ebisa form in fact electoral commission judge no na say nko obisa. But obisa no ya ma no ho kwan because na adiano any evidence no. And then yenya judge no opega say onhwe form yi na say form we no baby o wa yesa na form or the buyer no sa form no enye form e wo mrem form e wo mrem no enie CI 127 a kira form ko a yemfa declare results no in this when you use that form and declare results na results no e papa ana enye papa ni etwa to okura e atetia ene Dr. Pesa White or T adakanum na yeso na basa yeso na TV yeso na chi adentie sense asamo kano o kire kwantre ni esi odem ho emma ye lead counsel owura chatuchika the press story ka say we atetea ne obroni friend harassment no emfata say ebesi Supreme Court ma mu ina mu hui but enna ne esi no ye NDC for the M say ye ni age akon yie senia na ye pe no nokre no achiase edi na enim se ye kwa enim no nokre na nkasa ebededi ya san file application bi ye pese
ye kokotwe electoral commission documents odima ina original na odima ye no ye pese ye kokotwe ochina na Supreme Court behwe no ohwe no nso a ye beto tefo ye demo ase.
Thank you. Good summary. Good summary. Yeah. Yeah.
Baba, Nare. Ogo.
Then is a respondent. I feel the law. Oh, my jay. I told propaganda.
You have a good balance today.
Yeah. Colleagues, good afternoon. We want to share with you a few thoughts as the court rises to resume sitting tomorrow morning. First of all, we on the side of the second respondent view today's proceedings as a very excellent day in court. And it's an excellent day for us in court because the issues are beginning to unfold one after the other before the eyes of all Ghanaians. Remember, this is a petitioner who came to court praying or invoking the powers of the Supreme Court that the results of the 2020 presidential election, when properly collated, come to a point where nobody got 50%. And therefore, they are asking for a rerun. And you would expect that they put witnesses in the box to advance this argument or to provide evidence that buttresses this. Today, as you've seen before your very eyes, their witnesses are here making claims of bad faith, which claims are questionable, now raising questions of the venue of the declaration, now suggesting that in one breath they say they never saw the Form 13, in another breath what is being tendered before the court they say is not a Form 13. Now today 3 key matters have been settled in our opinion. The first is this fallacy that was being initially expressed and amplified through Dr. Michael Pesa-White, that the chairperson of the Electoral Commission instructed the representatives of the petitioner to leave the strong room, and on their blind side some numbers were put together and announced. We are beginning to see clearly that that fallacy at best is something that cannot stand cross-examination. You would notice that it's not just an interchange of words, instruction and asked. And I want you to take particular notice. When you read the petition, when you read the witness statement, the witness statement says, we were asked. Check the definition of asked. Now, in the witness box and under oath, he seeks to amend that and escalate the claim by saying they were instructed. And that's why you find the Venerable Akoto Ampao did not take too much time in his cross-examination. He asked one key question. He says, I put it to you that you know that you cannot be instructed by the chair of the first respondent. And you heard under oath, they could no longer tell that on truth. He said, yes, we cannot be instructed by the chair of the first respondent. And we are clear in our mind that that fallacy has been settled, and the court will take notice of it. That it cannot be true that the chair of the Electoral Commission would instruct and that the representatives of a candidate will obey that instruction. Indeed, questions as put by the counsel that you selected an option, you elected, and that you were derelict in your duty. That is what happened. And we are very happy that that is being settled. Another matter that is being settled is the attempt of the petitioner and his witnesses to surreptitiously question the results by discrediting their own agents. You notice that initially from the beginning of the case, they sought to make an argument that numbers had been cooked up and that the EC's computations were incorrect. Yesterday you saw the very skillful general with a calculator now arriving at 4751, 4751, 4751. Today they tried another tactic by trying to suggest that there was something wrong with the results that their agents had certified from the polling stations through the constituencies to the regions. And in cross-examination, you saw it clearly come out, and it's been settled that they could not use the back door to discredit their very own agents who certified the results from the bottom up and then claim that somebody from National had said that the figures did not add up. Another matter that we believe the court will take notice of is the attempt by counsel, and we believe successfully, to settle the dereliction of duty of the persons who were nominated by the petitioner to go into the strong room and assist in the collation of results. Now, please check. The NDC and candidate Mahama accredited 4 people. 4. In the end, 2. And this is after they had done their parallel collation. In their collation center with the TV screens, one of which you saw Mr. Mahama pointing that they were winning or that they had won, and then their press conferences. After certifying or accrediting 4, 2 went into the strong room and left. After all 16 regional returns had come in, and 13 of them had been certified by Rojo Metelnunu, who was the leader of the 2. And notice something interesting. Dr. Kpesa says that Rojo certified one of them in error. I'm sure as we go further, that will be dealt with also in addresses. That these representatives of the candidate ended up sitting there and even certifying some in error. It's a different matter that will be dealt with. But what is also instructive to note is that, and I think one of you asked a question, you are not judges. Many of you are not lawyers. But you even spotted it. Now, how can you claim to us from the beginning that this EC commissioner, we don't trust her? There are so many problems with her. In your press statement, you say she's doing the bidding of the MPP. Then you claim that she instructed you to go and consult your principal. And out of the 4 accredited people, the 2 who were there, both left. Why? And it was interesting listening to them. They said that they wanted to go and fill in the gaps. I'm sure you heard them, that they were going to fill in the gaps. One of the key things that is becoming interesting is why Rojo Metelnunu himself did not mount the witness box, take the oath, and say that he was instructed. We believe if he had done that, he would have been caught for perjury, because he cannot take an oath and tell an untruth. And that is why they have resorted to Dr. Kpesa, who now admits that he never spoke to or was never spoken to by the EC chair, yet he was a subject of an instruction and he was instructed. But the one who heard the instruction, the one who went to the office, is alive, is available, but refuses to take the witness box. We think that it is becoming very clear that as these matters are settled, and as we connect it to the principal issue of did anybody get more than 50%, was the declaration in breach of Article 63.3, the key questions will now come out and be answered. Now, another matter that we need to draw your attention to is this Form 13. There was this claim to suggest that the document that was shown to the witness was done through the back door and was not Form 13. First of all, let me make this point. Every practicing lawyer knows that after cross-examination, the bench has room to ask questions for clarification. And you hear the learned justices always say that we want to understand this one clearly. So to create an impression that when they ask you questions, they are harassing you, is part of the NDC strategy to begin to poison the minds of the general public against the bench. Because they can begin to see from the questions and the answers that they are giving, the gaps that are showing up in their case. Remember, they have already said that they think that this court is not a balanced panel. They have already been arguing that they have not been treated fairly and that some of the decisions don't make sense. Mareta Briopon. And today, they are furthering that by trying to poison the public by saying that they are being harassed. The bench has the right to ask questions. We believe that when our witnesses get into the box, they may even be asked questions. Nothing wrong with that. Now, this Form 13, which Mr. Kpesa under oath claimed did not have room to state reasons for non-signing, is on page 62 of CI 127. I want to encourage you, my colleagues in the media, pick a copy of CI 127 and look at it. The last column on your right says, reason if refused to sign.
That same column is available on the regional summary sheets at the constituency level. Why? Because it amounts to a certification of a complaint that will go up to the higher level. So if all your 275 constituency persons did not certify any complaint, and on your regional forms, you have gone ahead to certify all except Sehiwi also, which later Rojo Metonunu now certified in the strong room, and you claim he did it in error. You don't come with a bad case now to come and say that there was no space on the form to fill in a complaint. I'm sure you all heard it. The blatant untruths being told before the court. So we are very, very clear in our mind that the matters that the court has settled for itself, which is to determine whether or not nobody got 50%, whether or not the declaration was in breach of Article 63.3, as compared to the matters that they are seeking to attest to today, show clearly that what they've been saying, when put in the box and put under oath, is difficult to defend. We'll take your questions if you have any at this point. Yes. Go ahead, sir.
The import of any cross-examination is to discredit the petitioner. You've explained why your cross-examination by your lead counsel was short-lived, but do you think that he succeeded in discrediting the witness of the petitioner?
Well, as I've mentioned, the court in its final judgment would express its view on whether it believes it was successful or not. But as you all watched and followed on television, you saw a witness under oath say that there's no room to state reasons and be confronted with versions of it that show that there's room to state reasons. You also saw a witness who in his witness statement had earlier said that I was asked and I changed it to mean instructed. And then when put under further cross-examination that, but you know you cannot be instructed, admits that, well, actually I cannot be instructed. You saw a witness who claimed he had been trained, yet claims that somebody instructed him to act contrary to the training that he had been given. So it is not for us to determine whether or not it succeeded. You saw it, and we are hopeful that the bench will come to a conclusion on that at the end of the day. If you look at the case they brought and the witness they brought, was this witness here to prove that nobody got 50%? I'm not sure you heard that witness prove that. Was this witness here to prove that Article 63.3 had been breached? I'm not sure you heard that. This witness came at best to say that he was instructed together with Rojo to leave, and later when put to further cross-examination admitted that he cannot be instructed so to do. That was the main thing that this witness came to do. As to how that answers the question of 50% plus 1, I'm sure the bench will decide.
Also the question of the when and where of the declaration on the 9th of December. On your side, at what point did you know that the declaration was going to happen at the headquarters of the Electoral Commission?
I never saw in any of the pleadings, no paragraph, in which they raised an issue with the venue of the declaration of the presidential election results and suggest even faintly that therefore amounts to an illegality or an unconstitutionality. They never raised it even in their pleadings. So when you put a witness in the box and you have made pleadings, the gravamen of your case is that nobody won 50%. You have made pleadings, the gravamen of your case is that the declaration is unconstitutional. And you bring a witness and the crux of his argument is that I was instructed to leave. And they did the declaration in a different place than they had earlier announced. If it's our imagination, we look forward to what the court will say on that. What I find interesting is a comment made by Dr. Ayine here, that the exchanges between them and the bench today has no probative or has no effect on the probative value of the evidence they have put before the court. I find it very interesting. And I agree with him. We are hopeful that in a because this case can only end two ways, either we win or they win. In an event that they do not win, they do not come back to cite such matters, that this is why, because they have told you that they know from their 25 years of practice that it has no effect on the probative value of the evidence before the court. And we all look forward to that. My colleague Nanabi will do a quick chief summary for us.
Okay. Abu Sanfo, where there, Madama, ye bebono tau. Near the kind And I da a tosso and soon a bar court, and Dr. Pesa White, Adakam, near Tutuna, no Yenya who quaya, Nansa mana all cano NCC. Ubusano Asamoa, now or say the colleague Rojo Metonunu, Rojo Metonunu inso Yanfano Ama Metna Adakam. Near Tosumi, no Adibako said P and say. Openi aya Pesa White echo grantee interview on media for Kasai. Now I say a manimu 390,000. Yet the account Nana Ado Danko Kufuado the Yahu Ashanti region. And nay ebede di say and also na ya tro akwhwe na no odi. Adentia saa asem no oman ka ewo mo krata omo de beto eye court anim no. Ebiem se na omo kase wo hwe regions no any enema ankoso ye widespread irregularities just enema abatu man koso ye no ene ye sabeto edi say omo agents eyo na musifo a omo wo eye regions emu 13 edumiensa ena esign na emu bie ni hon so a otro se na wo asembo ni bi ewo ho a oka ebiem ene ne beto edi no so say agents so anomwo National Collation Center hoi Aya Rojo Metonunu ordinance share a manu dumienu ase aya krata from 13 no ode nensa ehyasie ansa na omu free ho ade ba ko esa beto adi enenso ne se opani Pesa White say aya EC chair Madam J Mensa ene share omo say omu free aya EC headquarters ono mo ne omo presidential candidate enkodi nkomo Abusuafo asemwe ene se hu se no so emu orem na yakofisem san se wo a yatetew wo ye agent wo ye obi anamu sini wo be ye adwuma ma obi esi de na nipa a ananu bia no mano esi ni so o ye kofini onye na adwuma ye o ye obi o ye bias na o ka kire wo se firi ho na gya wadwuma wo ye ho na wo so wagye na di ene ye hu se no so esa ye boslimuka na yakohwie ene ye se hu so se eye opani Pesa White se eye ono ane hu nipa ono ne ye adwuma meja metonunu yi o se krata ni bi ode ne sasha ase no o san wie ye no ana na adwuma na se mo hu se wa ye mfumso adenti ne nipa wa ye mfumso no yamfo no mo ametra da kam san se oboa ehu kakra bi enso ehye honom ebiem se wohwe enkomo a esa koso enenso a ade ba ko a ye san hu ye ene se moye agent mienu mo fantitiyem ye de munyina mo ba be gina honom ama eye omampani dada mahama na mo se bibi twetwe mo aso a esi den na mo kase mo mienu nyina no mo free ho na mo akọ boapayo omo boa sabre no na eye from 12 year free regions heba no emu duduo na aba ama mahu se omo pani a omo di nachi eye former president mahama no wadi ntwo wadi nkuguo ntina ewo se okọ nene ade ba ko a esa ye anigye ewo mram se ye toto eye dansini bia no a eye a judge from penifo etimi nso busansem ensemfo no ba ko a eye efree opani obapa getu tokuno ebusa se okay from 13 wo so afantitiem wo ho bi pen o se an me ho bi pen ena ode ne dia ekuta no ekere no ode kire no o se enye no a na nimra nim abusia eno so yasa kire mo se aya tro kese eye CI 127 ebinie se okọ eye page 62 and 63 a eye sample of the form 13 no ebi wo declaration of presidential resource form enye abusiafo etini omo sa begina afidie ye chisa kan ye se enimra mu no omoboa eno so yakohwie kese a eno so ebeto adi na ne kura no so beka ya eye judge penny obapa mariama owusu so busa se nyemdi kan na mo ye mienu ejade na mo fi se bibi twetwuma so kura ba ko pe enkatri no no hwe ne ye koso omanya anu ye enso ama justice yawapo ebusa se okay mujumadi a mudi nyina no mu ye agent. Now, do you act on the instructions of your principal and now say on the instructions of the EC na onye mujin say ayen shama mu say o say EC na asem o kamu diswa na say ba sa de na kamia kwa say adwuma ye de hye wonsa no e na wato ne pa ahwi e na wagya ho no mako eho opani chachu kasa o kan ye nyame anum no kure ne mu oya enye fe enya kasa ehho tie kra etimi ka kira judge penifo say they are harassing your witness. Very unfortunate statement. And BM Justice Mafusau and so ebusa say we will say one for when you kwasue ehho EC chair no one instructor one can hwe ankyerɛw etu kwan be na wo see nipa no fa so instructor so ampa o media man hu EC chair no na emom eye me colleague Rojo Metonunu ɛna ɛka kyerɛ me sɛ ɛyɛ EC sɛ yɛnkɔ na journalist na mo busa asɛm a emu odu pa no honam de ba bewie sɛ ɛbre bia no munya kwanya bia na EC musopa no mutwe na bo so muye ne ho fi na esi den obi a mungyini di na yatete mu agent mienu na yede mo akɔ na kachi sɛ munkonko gire mu ma former president Mahama na mo mienu nya sɛ mo jam laptop so ho o konso wo se wo phone so wan san fa charger anko anadwuma na sɛm be nie ɛna phone obi etu kwankɔ ne charger kɔ no wo de wo so kwakoda ba bi 2 days 3 days o kɔ refill charger etu phone adum went mine ni power small na ani nkomo munso a munyi ni pani ni amusu mienu nyina mokɔ na sɛnsɛm no nyina no akɔakɔyɛ anadwuma na sɛm ɛnukura wo mu ni sɛ omunim sɛ omadi ntwo omadi nkuguo enti also mu pɛ bibi na omode katakata mani nyame ya adom a court ahyɛ sɛ ɔkyena ene ebehia abusuafo sɛ ne amesrɛ mo no sɛ ne adam yɛ no mesrɛ panifo a ka yɛ ho ɛwɔ ha General Secretary of the ruling New Patriotic Party ɛyɛ ɔpani John Boadu ɛwɔ yɛn nkyɛn wɔ ha lawyer Nana Adwoa Adobia nso ɛwɔ yɛn nkyɛn ɛwɔ ha ɛna ɛyɛ yɛayɛ campaign chairman Mark Menu enso ewo ye nchen wa ha sei a lawyer for me hu lawyer Lenin enso ewo ye chi me hu aye national chairman enso na owo ha sei chairman Blay enso enel be kan ye ho a lawyer Akoto Ampao mo bo adwuma ye pa lawyer Frank Davis lawyer Yawopon lawyer Kwaku Asifi lawyer Adodapa lawyer Shelamin Kapremo lawyer Victoria Bath lawyer Ochre Ajekum lawyer Dr. Ernest Owusu Dapa, lawyer K. Amwa, Omunina Airboa Amadumadi Nakoso, Mehu, lawyer Lenin, and so ever Hasei. Eti Abusianfo, Nyamichra Bibia, lawyer Joyce Boateng, and so Eka, a year a lawyer for Omo, a Yami Aduma China, Yebe Shia, Beam our court here, Nyamishamu.
Well spoken.
So those were the two press conferences held by the petitioners, spokespersons for the petitioners' lawyers, as well as the spokespersons for the second respondent's lawyers. So what happened in court today was that the second witness for the petitioner, Dr. Michael Pesa-White, was in the witness box to testify to the claims of the petitioner. He was first cross-examined by the counsel for the first respondent, Mr. Justin Amenuvo, and after that he was also cross-examined very briefly by the counsel for the second respondent, who did not spend up to 3 minutes asking him. Basically, he asked him just one question to confirm whether or not he was asked to leave the strong room or he was instructed to leave the strong room. We have Nana Bwachinanabi, who is one of the spokespersons for the legal team of the second respondent. Thank you very much. We just heard you speak to the media, but again, for the purposes of education and breaking down the issues to our very many viewers. In court today, Dr. Michael Pesa-White exposed certain happenings at the EC. Indeed, he says that at the time the results were declared, the petitioners' representatives were absent. You have been following elections for some time. You are a national youth organizer for your party. What is usually the practice at the strong room, especially just before elections are declared?
Thank you very much. I mean, all of these practices, as you mentioned, I mean, they are all found in the law, majority of them. And again, the witness from Dr. Pesa-White obviously exposed the incoherent and then inconsistent nature as put out in his witness statement. Now, if you are an agent, you are not under the instructions of the Electoral Commission. You are under the instructions and you are representing your principal. In this case, your principal is the former President Mahama. So whatever goes in there, the EC, and then you have even been given the power. And then don't forget, before you even represent the former president or any candidate at all, the candidate would have to write a letter, would have to give you that authority by way of a particular document, which will be sent to the EC that Dr. Kwesa White is representing me, the candidate Mahama, and then Rojo Metonunu is also representing myself. So two candidates representing me. So clearly, you are not under the instructions of the Electoral Commission. You are under the instructions and then under the direct orders of your principal, in this case, Mr. Mahama. So for Mr. Kwesa White to say that they left on the instructions of the Electoral Commissioner, Madam Jane Mensah, when indeed in the box, he had also
yes.
let me finish this statement. When indeed in the box, he had admitted that he never personally saw the EC chair, and the EC chair never personally directed that instruction at him. So on what basis are you saying that you were instructed? And then we are told that, oh, it was my colleague Rojo Metonunu who had a discussion with him, and then he also came to tell me. Meanwhile, Rojo Metonunu is not in a witness box. So he's given a lot of incoherent, inconsistent testimony today.
But see, the issue also is that, and we spoke with the legal spokespersons for the legal team of the petitioner. They said they acted in good faith, that there was a consultation. Go and meet your candidate to discuss the issues that have come. Let's see. And then when they went away,
you yourself, I know you find this very, very.
No, just answer my questions.
Okay. First of all, a journalist asked a question, and then he said that you have always been on the heels of the Electoral Commission. You asked that question, fantastic. You have always castigated the Electoral Commission. You have always casted some doubt, right, on the work, on the constitutional obligations of the EC, to the point where you even dragged the Electoral Commission to court. So when did you start developing this kind of trust for the Electoral Commission? To the point where you have two agents, and the two agents decide that all of us, we are going. And then we leave behind our laptops and then our documents. I mean, this is just a clear, inconsistent, incoherent witness. So we cannot have a case where even before the elections, you even held a series of press conferences, right, chastising the Electoral Commission. So on what basis do you say that today, out of good faith, you acted on the instructions of the Electoral Commissioner, Madam Jane Mensah, and then go and see the petitioner, and then afterwards you come and then we declare? So you want everybody to wait for you? I mean, this is such, an unbelievable, very shaky, inconsistent witness.
You are one of the spokespersons for the legal team of the second respondent. We realized that the lead counsel for the second respondent, especially yesterday, spent the whole day cross-examining the first witness for the petitioner. Today he spent less than 3 minutes perhaps cross-examining the second witness for the petitioner. Why was that?
No, first of all, if you just oppose the two witness statements, I mean, they're obviously different. Mr. Esiedun Ketia is talking about some figures. Mr. Esiedun Ketia mentioned the vote pardon, vote aggregation. He also mentioned the fact that there were some issues with Eastern region. We also had to go to Techiman South. So you notice that there were some, calculations and then some collation-related issues. You get it? So that is the more reason why he had to take Mr. Esiedun Ketia through that process. He gave him a calculator, calculate this, and then from your own documents, he exposed and then he showed to him how in every step, in every corner, Nana Addo Dankwa Akufo-Addo secured 50% plus one vote. So today, you notice that he asked very important questions. Are you under the instructions of the EC or you are under the instructions of your principal? Then the answer, I'm under the instructions of my principal. Okay, so on what basis are you telling the court that you had to heed to the instructions of the Electoral Commission? And you notice that again there were 4 important questions, and today I find it very, very unfortunate for the lead counsel to have to engage in such a banter with the bench. I mean, to the point where he had to even categorically state that the bench is harassing the witness. Right. You know what? Let me end on this note. These 4 questions, very important questions. Now, you remember that Justice Mario Mousu asked that you were 2. So how come all the 2 went away? He could not answer. I mean, very, very shaky answer indeed. Then the next question also came from Justice Gertrude Tukuno. She showed the witness a copy of the Form 13. And then the witness said that this form is not in the law. But today we have shown you. Check the CI 127. The CI 127 has a copy of the Form 13, and the Form 13, there's a copy